me know when. So tonight's MCLE event by the Hellenic Law Society is presented by a past president of our group, Basil Plastiras, who has his own law firm in San Rafael, California, Plastiras and Teresi. He's a very well-known specialist in litigation, particularly attorney malpractice, attorney defense, and many other litigation matters. Tonight's topic is updates in the attorney ethics field and conflicts of interest issues. Basil, take it away.
Okay, thank you. I'll tell you a story from almost 50 years ago. I was working for a law firm as a new associate in the financial district, and one day, and this was in the late 70s, I guess, maybe 76, 77, a legal malpractice came into the firm, and nobody had ever handled a legal malpractice case there. And there were very, very few lawyers that did any kind of legal malpractice in those days because the suits were so few and far between at the time. Naturally, that changed. In any event, they said, well, let's give it to Basil. He can't screw it up any more than the rest of us. Apparently, they felt they were equally ignorant in this field. And so I handled the case, I wrote a letter up, and I got a call a week later from the attorney. And he says, okay, I read your letter. How much do I owe? And I gave him a number, and he says, okay, I'll send you a check. Click. And the attorney was James Picardo, who was a nationally known class action attorney. His firm is still down in San Jose. But in any event, by accident, I fell into this particular field. And unfortunately, in the 80s, the number of claims went through the roof. And part of the reason for that is that there were so few attorneys who were familiar with the claims and the defenses in legal malpractice cases. So a lot of attorneys had never handled one before, but they filed it anyway. And usually, most of the time, almost always actually, they were thrown out or defensed because people in those days just didn't know. We have more sophisticated lawyers now. And what I'm retiring now, but I will still continue to do expert witness work and consultation in legal malpractice, ethics, and fee disputes, which is I've been doing for 20 some odd years. We have a lot to talk about today, and the reason being that from 1992 until 2018, there were no substantive modifications to the rules of professional conduct. And in 2018, there was a huge change, and every year since, they've had additional changes. And you could get from the state bar a list of the rules of professional conduct. Up till 2018, those rules took up about 30 pages. They included not just the rules, but some recommendations and citations. In 2018, our rules of professional conduct they went crazy on it. In 2018, 19, 20, 21, 22, lots of changes. And what that effectively has done is doubled the size of the rules of professional conduct from 30 pages to 61, I think. And I want to talk about the rules because some of them are very new and some of them are quite controversial. The state of California has, for a long time, rejected any attempts to turn attorneys into snitches. But they have decided, along with the majority of the state bar associations, to impose a snitch rule that does require us to report to the state bar, subject to discipline if we don't, if any attorney that you know who did not come to you and reveal the offense in the course of an attorney-client representation, if they've committed any kind of a crime, engaged in any conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentations, or has engaged in conduct involving dishonesty or fraud, and if you happen to come across that, maybe they're an opposing counsel, or maybe just someone you talk to at a cocktail party, our obligation is now to report them to the state bar without undue delay. As soon as a lawyer reasonably believes that the reporting will not cause material prejudice or damage to the interests of a client of the reporting lawyer, or has committed any act that raises a substantial question as to the lawyer's honesty or fitness. This is Rule 8.3, and it is very controversial, and it's been widely criticized, I think, because a lot of lawyers don't want to be snitches, even if the opposing counsel did something unethical. And it's quite a burden on the legal profession because, frankly, there's a lot of lawyers out there that do things that are on the edge. And if we come across it, it's our obligation to report it now, starting in 2018. And the only exception to that is if a lawyer comes to you for legal advice and confesses that they've done something wrong. Under those circumstances, we do not have to report them because the attorney-client privilege will trump the obligations under this new rule. Now, if this does occur, there are two possibilities as to how to handle it. Actually, three. Number one is if it occurs during the course of litigation, the trial judge has jurisdiction over that, and that is the person to whom we're supposed to report. If it's not during active litigation that it's discovered, then we have an obligation to report it to the state bar. And as in response to the complaints that were made about this rule, they imposed a provision that says that you can report the behavior anonymously. And if you do it that way, they will give you a number. And you don't give them your name, they give you a number, the state bar. And if there's ever any investigation or disciplinary action pertaining to the failure to report, you're covered that way. So that is probably going to be the best way to do it, because a lot of times lawyers are resentful when their brethren report them. So that is the most controversial provision in the new set of rules.
Does that rule include judges too? Judges and ethical things?
You know what? No.
Interesting.
Yeah.
The judges have their own set of rules, and they also are regulated by
By the judicial.
California Judicial Council, I think.
Okay, that makes sense. All right, that's where you.
Yeah. And, we're seeing, I mean, when I started practicing, it was amazing what judges got away with.
Mm-hmm.
There was one judge over in Richmond, and nobody wanted to appear in front of him in the afternoon because he drank at lunch and it made him mean. And he got away with that for years. There was another judge who had a parrot in her chambers, and this was a very foul-mouthed parrot. And she too was eventually disciplined.
The parrot or the judge?
What's that?
The parrot or the judge?
Good question. I suspect both. Anyway.
Basil, what was the number of that new rule again?
Oh, it's 8.3. Rule of Professional Conduct 8.3. This was finally, the state bar agreed to support this provision after a California attorney, had been accused and proven to have swindled $18 million from his clients. And other lawyers knew about it and remained silent. So that's what made the State Bar Board give in on this. Even a reckless misrepresentation can fall within Rule 8.3. Hopefully, this rule, if there are reports of misconduct, will improve the legal profession and provide a basis to actually reduce the number of lawyers. If you look at the State Bar monthly report on disciplinary actions, in an average month, maybe 22 lawyers will be disbarred, could be 30. There were times when it was significantly higher. A lot of the disbarments arose during that period of time when everybody's home was in danger of foreclosure, and a lot of lawyers set up these mills to take in a lot of complainants. The problem was the lawyers did not understand the limitations on what fees could be charged. And so they just thought, oh, we're lawyers, we can charge whatever we want, and it wasn't the case. In any event, this rule will require us to make these reportings. And we're also required to keep abreast of changes in the law as part of this rule, including the benefits and risks associated with relevant technology as part of a lawyer's duty to perform their services. And that's Rule 1.1. The State Bar says that as a baseline, any attorney in this state should be proficient with the software programs in Microsoft Office. And they should also have the ability to convert documents from a Word to a PDF. And I don't know if you've noticed, but the entire court system in the state has been modified to make it better for the court system, but harder for us to file actions. They have to be formatted in very detailed ways. They also, at the same time, have to be flattened, meaning sealed, which can sometimes make the wording not subject to optical character recognition. And they will reject a lot of claims, a lot of complaints, because it doesn't meet the technical criteria. Basically, what you have to do is you have to, even if it's a form complaint, you have to make sure that the document is subject to OCR, so the court can find wording that they feel is important. The document also has to be what's called flattened. And that is where the document is essentially sealed, except for OCR. That's the only thing that they will allow. The easiest way to do that is to, first of all, a PDF can be converted to OCR pretty easily. And secondly, if you print the document electronically in Microsoft Print to PDF, that will take care of these other requirements. But it looks like we're going to have to get very familiar with them. And the courts of appeal and Supreme Court have done the same thing. They've really converted the entire system to their benefit. No surprise there, just to make it easier for them. So it's also important to keep up with revisions to the rules of professional conduct. And it's relatively easy to do that by going on to the State Bar website and accessing the rules of professional conduct. But there are just a lot of new rules. There were revisions to Rule 1.4, which regulates communications with clients, 1.15, pertaining to safekeeping of client funds, new requirements imposed there. There's a new rule of court, 9.85, establishing new regulations pertaining to client funds. Also a new State Bar rule pertaining to client trust accounting. And there are, now, if anybody has difficulty with trust accounting, what often happens, and I know so many lawyers who get caught when their trust account is overdrawn. By law, the banks must report that immediately to the state bar. And along comes the investigation. And sometimes, I mean, I've had clients who it was just an arithmetic error, and you really have to go through a lot of rigmarole to avoid substantial disciplinary action. So please be cautious about that. Now, the state bar does have free courses on trust account management, which would introduce you to these new regulations. And it's free, and you might even get credit for it. Also, any law firm that advertises its services in California, there is Rule of Professional Conduct 7.2, which allows attorneys to advertise via electronic means of communication, including public media, but these advertisements are subject to the same rules and restrictions that as any other attorney-client communication or solicitation. So be aware of that. And I mean, if you're not advertising on the TV, you're fine. Oh, and this is, I don't know if this pertains to anybody's practice, but the Board of Trustees of the Bar Association has approved the publication of a practical guide for the use of generative artificial intelligence in the practice of law. And I've seen a lot of that recently. Every software company seems to have their own AI program. And there are programs out there that will not just, one of them, I use case text, and that they will review the opposing party's brief and provide you with refuting authorities, and also provide you with supportive authorities, correct your grammar, and do all kinds of things. So I think pretty much at some point, all legal documents will be run by some AI service. But what I like about case law is you enter the opposing party's brief into their system, and they come up with case law that refutes or contradicts the brief's case law, saves a great deal of time and research. And I like it a lot. I think it's going to improve the practice of law. Let me see. There are so many new bar rules. I'm not going to go over all of them. There is on the state bar webpage, there's articles about trust accounting and about some of these other issues, and they're free to access. I'm looking for significant changes in the RPCs. Oh, if one of the new rules, it has to do with prohibiting discrimination or harassment. And this can occur in almost any context. If you're a lawyer, you're going to be subject to these state bar rules pertaining to that, but not just that, because those instances where there has been a complaint of prejudice or harassment, they report to the state bar, who also reports to the what is it called? The Department of Fair Employment and Housing, which has a new name. It's now the Department of Civil Rights. And they will investigate claims and so they have an online portal for attorneys to submit notices of state bar disciplinary charges. And you can go to the Department of Civil Rights and you can find that set of rules if it's ever pertinent in your practice. There's also new rules on safekeeping trust monies, and also new rules to speed up the delivery of funds to clients by lawyers. They must now, if there's a settlement and there's no conditions on it, then they must provide the client with the client's share of the recovered funds within 45 days. And if you don't do it, then you might be subject to disciplinary action. That is something that the State Bar has realized, that one of the primary complaints that clients make about their lawyers is, number one, they don't respond to my communications. And number two, they don't tell their clients when money has come in. And I think that is a very important obligation to do promptly. And if the State Bar finds out that it's been more than 45 days and or that the client was not notified, they will impose disciplinary sanctions. And there are new requirements under Rule 1.15, which addresses a lawyer's responsibility for handling entrusted funds properly. There apparently have been quite a few violations in that area. But if the lawyer has, absent good cause, the obligation to notify a client whenever money has been received for the benefit, at least in part, of the client. So they have 14 days to notify the client. See what else. There is now a rebuttable presumption that funds or property must be dispersed within 45 days. So you have to notify the client within 15 and distribute the funds within 45, unless they are subject to some settlement contingency that would cause a delay. But absent good cause, the failure to distribute funds within these deadlines can result in disciplinary action. There are some examples that the State Bar is providing that would extend the 45-day period. They might include medical liens, statutory liens, prior attorney liens, and any legal proceedings on the entitlement to the funds, such as an interpleader action. So under those circumstances, we will not be disciplined for exceeding the 45 days. We have, this is going to take maybe another hour, not tonight, but if there's sufficient interest, we can do this again and cover the things that I'm just not going to be able to get to tonight because of all these new State Bar rules. The State Bar also now has a State Bar client trust account protection program. and they will step in whenever there is a complaint from a client about not receiving their fair share. It's effective actually in 2023, but each year they are extending the reach of this sub-department. So we'll have to wait new rules to see what else they're going to require there. Also, that same rule is called CTAP, Client Trust Accounting Participation Program, Protection Program. A responsible attorney must certify that they are knowledgeable about and in compliance with the applicable rules and statutes governing client trust accounts and the safekeeping of funds. So if you do have a trust account, you have to inform yourself about the new rules. I did mention that the Department of Fair Employment, well, now the Department of Civil Rights, can and will investigate complaints about attorneys harassing or discriminating. There's an interesting new rule with the state bar, and it mimics rules that other states have created, that allows us to practice outside the state of California or in any other place, so long as there is the attorney in writing informs the client of the jurisdiction and jurisdictions in which they are entitled to practice. But if you do that, you can now take on out-of-state clients. So it might be an opportunity for some and a burden for others. And that is, let me see, I don't have the number for that rule. Oh, it's section 6090 in the Business and Profession Codes, 6090.8. Oh, and we as licensees are now required to inform the state bar of any other licensee who has conspired to engage in or has engaged in any of the following: seditious conspiracy, treason, rebellion, or insurrection. And this rule is triggered when an attorney has actual knowledge that another officer of the court is misbehaving. And this rule, the obligation to inform, still applies even if the licensee doesn't have direct knowledge, but has information from which the attorney can conclude, infer violations of this rule. So it's pretty broad. I'm not comfortable entirely with the whole snitch thing, but as I said before, it is the majority rule in this country. In other states. Also, there's a new rule that can discipline, where the state bar can discipline an attorney who makes a complaint to the state bar with the intent to intimidate, harass, or otherwise deter a fellow licensee from engaging in the lawful practice of law. And in so doing, that shall be deemed professional misconduct and subject us to further discipline. This is an interesting one too. I just had an incident, it was about 2 weeks ago. I got a call from an attorney that I had represented, and his daughter had just graduated from law school, and she and her girlfriends in undergraduate years had been subject to some discipline. It wasn't major, but it was technically wrong. And the question was, do these candidates have to report that to the state bar? And that is going to have to be resolved by further cases and professional opinions. But if any lawyer, in relation to their own application for admission to the bar, makes a statement of material fact that the lawyer knows to be false, or it's made with reckless disregard as to the truth, the lawyer shall not support that candidate's application to the state bar. And a lawyer can be subject to discipline for so doing if they are shown to be aware of the ethical issues involved. Let's see. There are new rules now, 8.11, 8.2 through 8.5, that provide further definitions of misconduct and discipline. And if you ever have the misfortune to have the state bar contact you, you will want to review those. It's interesting how regulated lawyers are. The rules and regulations regulating lawyers are contained in 19 of California's codes. I don't know how many California codes there are, but there's even one in the water code that purports to regulate attorneys, as the insurance code and the B&P code. Generally, these ethical rules cover important duties that we owe: diligence, communication, and confidentiality, as well as our obligation to be open and honest with the courts. Let's see. Lawyers are now, by the rules of ethics, obligated to act promptly and with reasonable diligence in handling any client's legal matters, including keeping the clients informed as to the status. I'm not going to go over Rule 1.4, but that is the rule, if you want to take a look at it, that regulates the attorney's communications with the client. Rule 1.7 prohibits any representation by an attorney if there is a significant risk that the attorney's loyalty or ability to represent the client effectively will be compromised. And of course, lawyers are now expressly required to disclose any conflicts of interest to all the affected parties. Rule 1.6 addresses the duty of an attorney to be open and forthright, and I'm sure that that is a rule that is going to result in a lot of future complaints to the state bar. With regard to fees, attorneys must ensure that their fees now are reasonable and not excessive. There's always been fights over attorneys' fees, and I've seen the courts apply a broad range of possibilities there. But it's not, it never before has been as specific as the rules now require. In negotiations, any communications with opposing parties or opposing counsel, we are now subject to rules that can result in discipline if we are not open and forthright with opposing counsel. The state bar has adopted a set of rules to improve the honesty, integrity of the state bar, that being one of them. We owe duties not just to our pending clients, but our past clients to protect confidentiality and to any potential future client. And we also, once again, Rule 3.4 requires us to be fair to opposing party and counsel. And it's going to be interesting to see how that plays out in the long run. Imposing such a rule, I could see that there could be plenty of violations and justifications for them, for the benefit of the client, but we'll have to see how far the state bar wants to take this. In my experience, the key to disciplinary action tends to reside in the lawyer that is appointed as the chief trial counsel for the state bar. Sometimes they're really tough and sometimes they're lax about some things, while tough on others. So it's just a question of who's in the office and what are their primary objectives. The State Bar Act has been extensively modified. That's in the B&P Code 6000 through 6243. I've mentioned most of the pertinent changes. But it's important to take a look at those sections to make sure that you're in compliance. Now, we're not just regulated by the rules of professional conduct and the water code. There is extensive regulations now in the California State Bar Act, which is Title IV in the Business and Professions Code. The Act grants the state bar now regulatory authority over the legal profession in California. including establishment of rules of professional conduct that lawyers must follow, investigation of complaints against attorneys, and discipline for ethical violations is now a part of the B&P. I don't know if that's going to substantively change the way the state bar investigates potential violations or not, but they've gone a long way towards imposing statutory regulation upon lawyers. We'll see how much pushback there is. California Rules of Court is also a source of regulation of lawyers that pertains to ethical rules and violations. You ought to review the Series 9 rules, California Rules of Court, if you're going to be involved in litigation. They now prescribe the oath that an attorney must take in order to be admitted. They've added additional language required now by Business and Professions Code 6067. I also suggest that you peruse the state bar webpage. There's so much information there. They have a compendium of legal ethical opinions going back many years that provide great detail with regards to attorneys' conduct or misconduct. I remember some years ago when I was still in the financial district, the state bar had come out with an ethics opinion regarding the consequences of an attorney having an affair with his client's wife. And I passed that around to my associates and asked them, what does the state bar mean when they advise attorneys to behave with extreme caution when contemplating sex with their client's spouse? And one attorney said, carry a gun. Another attorney said, what did he say? The third attorney, who was one of the more intellectual attorneys at my firm, said, it means to get the client's written consent in writing beforehand. Now, some bar associations in California, San Francisco, LA, Orange, and San Diego, also publish their own ethical opinions when they review a situation, usually as a result of someone's complaint. And they're a great source of ethical rules. You may not know that you can actually call up the state bar with an ethical question, and their staff there will refer you to pertinent statutes and cases. And I've done that several times now, and it's been very helpful. And by the way, that it's the California Compendium on Professional Responsibility, it's a 3-volume set that contains important rules and interpretations proffered by the State Bar Committee on Ethics and also State Bar hearing officers. A lot of it pertains to disputes over fees, but there is a lot of good information in there. There's also the California Code of Judicial Conduct, which is worth reviewing. Again, Rule 8.3, our obligation is now to report any officer of the court who misbehaves in such a way as to raise a substantial question as to that attorney's honesty or fitness to practice law. That's pretty much what I've got on the state bar. I could talk a little bit about today about avoiding medical malpractice claims. And there is a good deal to be said there. That usually takes its own hour. And if there is enough interest, then I'll be happy to go over that in a later seminar. One of the things that they talk about are avoiding problem clients. If the potential client has already seen 2 or 3 other attorneys, and they're still looking for an attorney, that's a sign that very likely the case doesn't have much merit. And the bar recommends that we beware of clients who seem convinced that all of the legal issues they face or faced in the underlying action or face in the malpractice action resulted from ineffectiveness of their counsel. As a practical matter, that it's rare that an attorney screws up in half a dozen ways, at least ways that make a difference. And in my experience, I've tried close to 30 legal malpractice cases. They're very hard to win. Out of the hundreds of cases that I handled or tried, I mean, we paid out money very rarely because usually it was a judgment call by the lawyer predicting the outcome of a certain trial. Well, we are not clairvoyant and are not charged with doing that. And in addition, we often rely upon medical experts or other accounting or technical experts for their advice, and we are entitled to do so unless we have a reason to believe that they're not competent. The state bar discourages attorneys from taking cases outside of their usual and customary practice. They recommend that if you want to do that, that you associate in an attorney with experience in the pertinent field. It's a good idea to consider that just to get a second mind in. But the idea is also to avoid mistakes that, because the attorney is not familiar with that particular field of law. Let's see, I think that's all I have right now. We can talk a little more about, we've got 5 minutes. The key to avoiding malpractice claims is to be very careful about who you accept as a client, to vet the client thoroughly, to anticipate what potential conflicts might arise, or when the client may need a different kind of attorney. The classic case is a PI attorney who takes a case without realizing that there is also a companion workers' comp entitlement. And if the attorney doesn't refer the client to a workers' comp attorney or handle the workers' comp case, they are often liable for the damages that they from the rising from benefits that they could have acquired but did not receive. In my experience, though, attorneys are often mistaken. They are often negligent. But I would say that 90% of the time, their negligence had nothing to do with the plaintiff's damages. Most of the cases I've won have not been decided by a jury that the attorney wasn't negligent. What they most often find is that the negligence just didn't cause any damages. Just because the attorney was mistaken about something, that does not mean that they are liable for all the damages or any of the damages necessarily that the plaintiff, former client, could claim. But once again, it is to our mutual benefit to be cautious when accepting cases, vet the client well, and there are a lot of litigation-prone people out there. They will sue at the drop of a hat. And I had one case years ago. We spent 62 days in trial on it. They were suing 3 law firms because they claimed that the woman had been horribly sexually harassed at a beer distributorship where she worked. She was the first female salesperson there. But ultimately it turned out, and the jury decided, that she had a mental condition that resulted in her interpreting innocent language in a sexual context. But it took 3 months to get that straight, and it would have been a lot easier if these law firms, all 3 of them, had sent a formal letter to the potential client rejecting the case. So I think that's something that, was over $1 million in attorney's fees defending these cases. And it could have been easily avoided by simply saying, I don't want to take your case. You don't even have to give a reason. The interesting part of this case was that this woman's husband was an adjuster with State Farm Insurance, and he was the supposed mastermind of the whole claim. But in any event, you have to be careful, especially when it comes to any case involving sex. That's a very explosive issue to a lot of people. And I think that it bears caution when cases like that come before you. I've had quite a few cases defending attorneys for sexual harassment. And I will say that most of the time it's not supported by the evidence. But who wants to go through a trial when you're accused of sexual harassment? That's about it now. It's 6 o'clock. Does anybody have any questions? I see you've all been busy looking at your screen.
Basil, I have a sort of an interesting situation. This information you've given about 8.3, the rule, is interesting. I have a client group that includes an attorney that works with a public official that's an attorney. And this public official is very belligerent, very antagonistic, very attacks the group around her, staff members, makes a lot of terrible comments about them, and is the kind of lawyer that I'm sure all of us have run into over time that we think really is not the right kind of person to practice law, because they just abuse their power, their position, their status. And I'm just thinking, my client actually, ironically, was talking to me right before this call about what he could do to challenge this public official short of a recall. And I'm thinking the complaint on 8.3 could be fashioned pretty effectively. Does that make sense to you?
Yes, it does. Depending on the evidence, uh, it does have to be substantial. But if this person is really out of line, I suspect the state bar will step in. This seems to be the new theme of the state bar: courtesy and honesty. Uh, so yeah, if they're an attorney and they are acting contrary to the law with regard to employees or other attorneys or associates, they now can be subject to discipline under 8.3. So, and you can also report them to the Department of Civil Rights, and you can even do that anonymously. So,
Is that the Department of Civil Rights? My client mentioned something like that about a civil action that can be filed against them. Is
well,
that
you can always
where you
file
file
a
it?
civil action for harassment, but depending on the situation, I don't think it's for the benefit of everybody involved to do that. It just creates more. The idea of getting a government agency involved to at least look at it seems to me to be a, a quick and equitable way to address the claims.
Hmm. Well, thank you for this information. This was very provident.
Yeah.
I was talking with the client right literally 5 minutes before the call.
Geez.
So
Yeah.
I actually had occasion to file a complaint against another attorney under 8.3. And what happened was the firm I worked for part-time was litigating a real estate case where the other attorney was holding about $1.2 million from the sale of the house proceeds. We asked him for an accounting and he wouldn't give it to us. He kept stalling around and not giving us bank statements. And we finally got him out of him after almost a year. We discovered that while holding the money, he had used some of it to pay his office expenses and had actually dispersed and had to replace over $400,000 to his client, without authorization.
Yeah.
So, that's obviously something that, but by the time he had given us the accounting, he'd replaced all the money.
Oh,
We ended up getting, it became clear that's what he was doing. He was stalling while he was scrambling.
yeah. He's probably has rotating victims.
Probably. But I filed a complaint against this guy 2 years ago. And I just out of curiosity, I checked. When I first did it, the state bar investigator called me up and talked to me about it and had me send over all the bank statements and stuff. And I hadn't heard from him for a long time. And so I checked and he's still practicing law.
Well,
this is something, that the state bar is usually all over client trust fund.
yes, and they always require the attorney who's accused of that kind of violation to take particular courses in managing trust money, reporting to the state bar. So it's possible they did something. It's possible it was a clerical error on the attorney's part, but at least he might have been able to convince the state bar of that.
Yeah.
But when it comes to money and trust funds, they're generally quite they jump on it.
what happened with the distribution of the client is that the parties had kind of orally agreed to a settlement, but hadn't signed the documents yet. And our client changed his mind and backed out. But in the meantime, he decided to give his client the money without waiting for the paperwork to get signed.
Yeah.
And so he was, but the other thing, of course, is that he also, used some of the money for office expenses too. And so this is certainly, just given the size of the amount,
Yeah.
this would normally result in disbarment,
Yeah.
even when it's placed. And of
It's
course,
possible. Yeah.
but they had,
But you could always follow up, and sometimes, well, let's see. The lawyer was not disciplined then.
not yet. Not
Not
yet.
yet. Yeah.
And there's a notice they put on your profile when charges are filed. There isn't even a notice of filed charges yet, and it's been a while, maybe 2 years.
Wow. Well, yeah, he could be on some kind of a rehabilitation program. Oh, and by the way, the state bar does impose confidentiality requirements in a variety of situations, not just attorney-client. But if you happen to be in a substance abuse group for treatment, you cannot report an attorney for what they say in that kind of a setting. So you don't want to rush to the state bar right away. Okay, I guess, any other questions? All right. Is there any interest, and it's okay if there isn't, but if there's any interest in getting into the nuts and bolts of legal malpractice claims, we can do that another time and very likely get units for it. I know in the past when I've done this, they've given us units. But there has to be an interest, and I know there's a lot of other things out there you could be doing.
Well, Basil, I will bring it to the committee, and